Greg
Oh.
and Greg and Justin, can we plan to confer, say, 20 minutes after we adjourn?
Sure.
Okay.
Sounds great.
Okay, good.
I am waiting for one attorney to start their video. Mr. Konopka, if you could please turn your video on.
Can you see me now?
I can.
Thank you.
Thank you very much. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-1033 et al. Long Island Power Authority and Long Island Lighting Company, doing business as LIPA petitioners versus Federal Energy Regulatory Commission. Mr. McBride for the petitioners, Long Island Power Authority et al. Mr. Konopka for the petitioner, Linden VFT LLC. Mr. Viswanathan for the respondents. Mr. Longstreth for the respondent interveners.
All right, Mr. McBride, good morning.
Good morning, Judge Henderson, and may it please the court. The Seventh Circuit's mandate was to quantify the benefits for each of the vintage projects at issue. FERC failed to do that or to cite any testimony or other evidence doing so for each of the three categories of costs at issue. For the pre-2016 costs, the debits and credits agreed to in the settlement were a black box settlement. That is, no explanation of how the amounts were derived. Merchants were supposedly no worse off than if we had litigated the matter, but that is just a cost-to-cost comparison, not a cost-benefit comparison, and it presumes the conclusion of the methodology that FERC would have used had the case gone to hearing. And we were worse off, as we demonstrated in our reply brief at note 3. For the pre-2016 costs, our costs went up about 5.8 million, and overall our total costs went up from 16 million to 31 million. For the second category, for the canceled projects, FERC's rationale was that it could rely on so-called violations-based defects, even though it had previously rejected that method, because it hadn't, it said, rejected it as the sole means of cost allocation. But in fact, FERC was urged by the Illinois Commerce Commission to use that violations-based defects for part of the cost allocation, and FERC's response was to reject it altogether. That's at JA 461. FERC has not justified how it is now justified to use that methodology that it previously rejected. For the cost starting on January 1, 2016.
Mr. McBride, if
Yes.
I could interrupt you.
Yes, Your Honor.
The Seventh Circuit made clear that the postage stamp method won't work. And I'm sure you would not want 100% flow-based method. So what do you propose? What ratio is it that you think FERC should have chosen?
Well, for one thing, Your Honor, what we really were contending here is that we needed to have an as-applied determination. So even if you start with the Order 1000 hybrid methodology, there were aspects of the settlement that were highly prejudicial and that we had no part in negotiating, such as for de minimis and for netting. So for de minimis, for example, a system as large as PSE&G would, if a project had a load of less than 1% of PSE&G's total load, and so that 1% would be 1,150 megawatts. You'll find that at JA 150. Then PSE&G would bear no costs for that project altogether. And those costs would be reallocated to the other participants, and particularly the merchants. And as to netting, netting is useful for the big systems like PSE&G and the others because they have flow in two directions. But as Linden pointed out at JA 163, netting doesn't even apply to the merchants because the flow is only in one direction.
But let's be honest on the big conceptual question that was at issue in the Seventh Circuit cases and in Old Dominion, which is where on the spectrum between postage stamp and flow is what is the appropriate mix of cost for high voltage facilities? You want postage stamp.
We didn't argue for that as the only method, Judge. We said it was an alternative.
The hybrid, the one-to-one hybrid is $30 million worse for your clients, and a DFAX only method would be even worse.
Well, our showing, the commission's finding at JA 353 and 398 was that we were $31 million of additional or total costs as opposed to 16 million. So it's the settlement and the provisions of the settlement that are really the problem, Judge.
The settlement which implements the one-to-one methodology that is now routinely used in under Order 1000.
But it's not just the one-to-one, as I was just indicating. It also includes the aspects like de minimis and netting that were highly prejudicial to us.
Okay, so if you don't, if you're not pressing the conceptual point, what I call the macro point of pure postage stamp versus pure DFAX versus some kind of hybrid, and what you're saying instead is that there were a lot of subsidiary details that FERC should have looked at more closely instead of just making this overall ballpark judgment. That seems like that's just a challenge to their Trailblazer framework, no?
No, Your Honor, that's,
Why?
Trailblazer 2, which was their basis here, is just to make an overall determination that it's just and reasonable without looking at the component parts. And I'm urging that they would have had to look at the component
You're
parts.
saying, exactly. So you're saying that Trailblazer 2 is not a lawful way for FERC to approve contested settlements?
Perhaps in other contexts, but here where we had the mandate and cost benefit was required, and we needed discovery to show what the assumptions were in the models and what the power flow data were, the base period for which they were used, and that sort of thing, and to force the interveners to put on a case that showed cost benefit, and then we could put on an opposing case, and then FERC would have to resolve the disputes.
Right, but I mean, neither Illinois Central case involved approval of a settlement. So however, I mean, whatever you think of the mixed signals from Judge Posner's opinions, they really don't speak to the Trailblazer question that we've been discussing, which is in the settlement context, is it good enough for FERC just to look at something overall, or are they legally required to separately address all of the granular details that you're pressing on us now?
Judge Posner and the other members of the Seventh Circuit, of course, didn't have a settlement in front of them. But our point here was that when we contested this and we showed that the methodology, despite the interveners' assertions that we would be better off, we weren't better off, we were worse off, and that we were entitled to show that there were problems with the settlement that made us so. And so it was really an as-applied challenge that we were trying to present and that we were prevented from presenting.
So do you quarrel with FERC's reasoning to the extent they said that we now have the hybrid 50-50 methodology, which we use. We approved it in 2013. It's produced consensus among all of these utilities who had been at each other's throats. So we are going to apply that methodology here. Do you dispute that aspect of their reasoning? I thought your whole case was that they can't do that. They have to redo the 2013 compliance determination in the context of this administrative record.
Well, note that FERC itself said at JA3 that the hybrid methodology was just an outline. And our point here was that as applied to these projects, and we showed this in our comments contesting the settlement, the basis for the settlement that we were supposedly better off was not correct. And that when you included the Susquehanna-Roseland project, for example, we were a lot worse off. And those are the tables at JA 353 and 398.
Sure, I understand you're worse off, but they said that in the but-for world where you litigate, you weren't going to get the postage stamp method that you want. You're going to get a hybrid.
Well, again,
you're going to get the rule of law you get here will be the 1-to-1, the 50-50 rule that FERC uses, and the arcane adjustments under this three-track method is designed roughly to replicate what you would get under the 50-50 Order 1000 approach.
Well, the problem that we had is it's not just this 50-50 approach. That's the problem. It was a settlement that had a lot of other provisions in it that were prejudicial to us.
But that's what I'm just trying to isolate here. Are you complaining about applying the 50-50 rule, or are you complaining about all this other details?
Well, it's very difficult to answer fully, Your Honor, because the interveners, who were the parties who had the burden below, would have had to present cost-benefit testimony to justify the settlement. And FERC itself said that that's what was required at JA 67 in the order on remand. And then we would have been able to present cost-benefit testimony in the alternative, showing what was wrong with their testimony. And that's what the hearing would have been about. So it's not just the conceptual, but it's the as applied that I'm trying to explain was really our concern here.
Okay.
All right, if there are no more questions, then we'll hear from Mr. Konopka.
Can you hear me?
Yes.
Great. Good morning, Your Honors, and may it please the court. Eric Konopka for Linden VFT. Up to this point, we've been talking about reasons why the settlement should not be upheld. But if it is upheld, it should at least be interpreted and enforced according to its terms. That means Linden VFT cannot be held liable for transmission enhancement charge adjustments because it was not subject to transmission enhancement charges at any point during the period in which adjustments are collected. Now, I don't have a lot of time, and I'd really like to stress 2 points. First is that on the text, there are really 2 key phrases here, and it's in which and are collected. If the settlement had said, for example, the period for which adjustments are collected, or the period in which adjustments accrue, then FERC's interpretation of it may make sense, but those aren't the words that the settlement uses, and the words that the settlement does use in which adjustments are collected are used not only in the paragraph that we're relying on, 2.2E2, but also in the very next paragraph, 2.2E3, and nearly identical words are used in the prior paragraph, 2.2E1 of the settlement. So these weren't, this wasn't an accident, it wasn't an error, these words were chosen. The second point, and it's related.
Your position seems pretty strong on the language of Schedule 12C, but what do you do with the language in the settlement agreement? I think there's some JA 88, JA 86. There's a formulation which says effective 1/1/16, which is the effective date, not the approval date. PJM shall collect.
Sure.
Isn't that some, at least a clue that collect in this context might have a counterintuitive meaning of accrue?
Sure. So a couple of points on that, Judge Katsas. Number one, we think that the two provisions are actually reconcilable, and we've reconciled them in our brief. But if the court perceived any conflict between them, then we think that the tariff should govern, that the Schedule 12C should govern. And FERC itself, in its briefing, focuses on Schedule 12C. So that's the filed rate that should be applied to us, and so the language of that really should control. But we think that they're totally reconcilable because of the way that the settlement works, and it may be worth kind of giving our conception of how it's supposed to work. So sections 2.2b and sections 2.2d and e of the settlement they incorporate a list of dollar amounts that were assigned to us by the settling parties in an appendix to Schedule 12C. Now, sections 2.2b and sections 2.2e make clear that those amounts are subject to change depending on the exceptions, the exception that we're relying on, as well as another one. So the way that we think that this has to work is that you apply our exception first, 2.2e2 first, and that has the effect of zeroing out our adjustment number, and then other parties' adjustments would be increased by a very small amount, about 0.8% to account for us. And then those amounts would have to be made retroactive to January 1st, 2016, including with interest. And we think that's how the settlement operates. And we think, again, sort of getting to my second point, that's for good reason. I mean, we don't have a ton of insight into why the settlement was drafted this way, but the provision that we're relying on seems to be an administrative one. What it's basically saying is that, when we gave up our firm transmission withdrawal rates, we stopped being liable for transmission enhancement charges. PJM stopped billing them for us and stopped collecting them from us. And so what this settlement provision is really saying is that if PJM isn't billing you and collecting charges from you, then it shouldn't bill and collect you for adjustments either. And we think that's buttressed, among other places, in section 2.2b, which makes clear that PJM shall collect adjustments as a separate line item on customers' bills. Thank you, Your Honors. I see I'm out of time.
All right, we'll give you the minute you requested in reply.
Thank you, Judge Henderson.
We'll hear from FERC counsel, Mr. Viswanathan.
Good morning, Your Honors. Anand Viswanathan on behalf of the Commission. I'll start off with where we left off on the language of the settlement. Judge Katsas, you pointed out the provision of section 2.2d that states that effective January 1, 2016, PJM shall collect. I can also ask you to compare that language and that usage of collect with section 3 of Schedule 12C, which uses the word collect in a slightly different way. That's the provision that says that PJM shall track and accumulate.
Where are you? You said D, which is the JA 88.
Right, and I'm asking you to compare that with what's on JA 100, which is section 3 of Schedule 12C.
88 seems to me doesn't help you as much because it says collect or credit. So that could easily just mean from in the transition period from 16 to 18, they're not collecting, but they're crediting.
Well, okay, but it also uses the same phrase that's used in section 4C12 of Schedule 12C, as well as three of that schedule.
I'm sorry, 4C12. Okay, that's the main provision.
Right, that's the provision that's been disputed. And so I guess my first point is that Linden is focused on the phrase collected in that provision, but I think what the commission is trying to convey is that that word is used in a few different places in the settlement, and it means slightly different things. And so on the prior page, J100, what it says is that between January 1, 2016 and the date of a FERC order authorizing PJM to begin collecting, so that's one usage of that word. And then if you compare that use of collect with 2.2D, which states that PJM shall collect or credit on effective January 1, 2016, I think based on that, the commission found that it's a more reasonable reading of 4C12 is that it's referring to the entirety of the time period. Another point the commission focused on is not just that phrase in 4C12, but the entirety of the sentence in which it is located. And so what it says is during the period in which transmission and enhancement charge adjustments are collected. And so there's no definition or explanation of what that time period is in that provision. The closest time period we have is in the preceding umbrella paragraph in 4C, which is what the commission called the entire adjustment period of.
You wouldn't disagree if we start from the directly controlling text and work our way outwards. By far, the more natural reading of collect is to collect the money, forced transfer of money from the utilities to PJM, as opposed to accruing the liability on the recording the liability on the balance sheet of the utilities, right?
Well, but I think when you consider the entirety of the settlement and other provisions, I think that's when that reading starts to make less sense.
Yeah, but I'm not sure the other provisions help you very much. So, I mean, just working outward from that provision of the tariff, one provision later, you have paragraph 5, which contrasts collection with payment. And one paragraph earlier, the section you were talking about is an entire regime set up to deal with this transitional issue of the 2-year period between the effective date and the when the liabilities kick in, and the approval date when PJM can start the collection. I mean, it all seems, everything in the tariff seems to hang together to support Linden's view.
I'm not sure that's right. I think I can point you to one more provision, Judge Katsas. This is on.
Because the best one I could find for you are the provisions in the settlement offer, and I don't know that those have quite the same weight. But go ahead, within 12C.
Sure. Well, so at least, I was going to point you to one of the terms of the settlement itself on JA 85. This is 2.1, and this.
I'll let you do that in a second. But do you have anything in 12C that you want to start with, or are you? I think that 12C, I think are what I've already said, which is number one, the tracking and accumulating obligation in section 3. And this is important because if Linden is right, that means that their reading of 4C12 is focused on that word collect would essentially undo the tracking and accumulating obligation in section 3 of 12C. And the other piece is what I've already said, which is the only time period that's actually defined in 12C is the one in the umbrella paragraph 4C. And so it's a reasonable reading of 4C12 that during the period in which the adjustments are collected must refer back to the period where that's defined. I can also point you to the last sentence or last phrase in 4C, which says, this is at the end of 4C, it says, subject to adjustment in accordance with subsection 4C1. And so I think a reasonable reading of that is that what follows 4C, that is subsections 1 and 2 of 4C1, are subject to what has previously been stated in 4C, and 4C is where we have that full adjustment period of 2016 to 2025. So that's what I have for you on 12C. I can just point you to back in the settlement, JA 85. This is section 2.1. The commission emphasized that, so this is the provision that explicitly in the settlement separates out the effective date for adjustments and the effective date of the settlement itself. And that latter date is dependent on when the commission actually approves the settlement itself. So the point of this here is that regardless of any, for example, delays in approval of the settlement, that doesn't change the fact that adjustments are effective as of January 1, 2016. They continue to accrue.
Can I take you back to JA 100?
Yes.
the paragraph 3 that you suggested is probably the most helpful to you. I read in a different way, and wonder if you can tell me where you think I went off track here. PJM shall track and accumulate the differences between amounts collected. So to me, and then they're going to take that amount and they're going to subtract basically what 12C otherwise would have required. Track and accumulate the difference. So we're talking about a subtraction here between the amounts collected versus the rates and charges applicable under this Schedule 12C. And so that kind of subtraction problem to me really only makes sense if collected is the kind of collect that Linden is talking about, because you wouldn't take as your first amount in that equation what perhaps a company was billed but didn't actually end up paying. You would want to know what they actually paid, what was actually collected from that company. That's the amount that you would then use and then subtract from that what should have been collected under 12C. Imagine that I'm just a customer and a company is trying to figure out what I owe them versus what they owe me. And what should have been paid is what it was under Schedule 12C. What are they going to compare that to? They're going to compare that to what I actually paid them, what that company actually collected. They're not going to compare it to maybe a bill they sent me that I never actually paid and that they never actually collected. So to me, don't tell me why I'm wrong. Tell me why I'm misunderstanding how the word collected is being used there.
Well, I think I think what you're saying is sort of premised on the fact that maybe the bills have already been collected. And so what the settlement is covering is amounts that were already collected, as well as amounts that would be due under the previously remanded method. The post.
Well, they're taking the first of those and they're subtracting from that the second of those, right?
I mean, it's not necessarily subtraction, because if you paid a certain amount under the postage stamp and you are now under the new method, you need to pay more money, then it wouldn't be a subtraction, it would be a payment. So that's why I think there's references to both payments and credits throughout the settlement.
Right, but you could subtract. You could say 3 minus 4 equals -1, and that would be a credit. Or you could say, let's say that it was 5 minus 3, that would be 2, so that would be a debit. But my point is, when you're trying to contrast what is applicable under 12C with some other number, and then you're using those two in an equation to get what is owed either to or from PJM, you would take what was actually collected, what was literally obtained from the company, and then you would say, let's compare that amount that was obtained from the company with what 12C says should have been obtained, right?
Again, assuming we're talking about amounts that have already been paid, but there are ongoing costs with respect to these facilities. Obviously, these transmission lines exist for decades and there's annual costs. And so now the settlement is changing the amount of costs that are allocated. That is the costs that have already been paid for these facilities, as well as costs that are going to be paid going forward. So it's not necessarily the case that the amounts that we're talking about are all amounts that have already been paid for. And so what the postage stamp method said is you already paid a certain amount based on your share of the entire network, and you continue to pay that share going forward, and the settlement changes that calculus. And so that's why there's a difference in terminology for what we've called the pre-2016 costs, which were already paid. And so the settlement's adjusting those versus what are called the current recovery charges, which are the costs going forward post-2016. And I think that what the commission tried to emphasize here is that there's an obligation on PJM's part to track and accumulate these liabilities starting in 2016 up until the point where PJM's authorized to actually go out and get the money. And so if Linden was right about about their reading of 4C12. That essentially means that a private party like Linden, all it has to do to get out of its liabilities under the settlement is to just beat the commission to the punch. And I think that what the commission was trying to do is read all of these provisions in a way that gave all of them meaning. And if Linden's right, that means that the ability of PJM to go out and get this money, it would be severely hampered. I'll just add here that this court has consistently deferred to the commission on its reasonable interpretations of settlement language. Try to see if I have other provisions for you. So I think that based on what we've seen in 4C12, I don't think you can read 4C12 as clear and unambiguous as Linden has argued. So then the question on is whether the commission's interpretation is reasonable. It's not an unreasonable interpretation if we can come up with a different interpretation. The question is whether the commission's interpretation is reasonable. If I can step back and go to some of the court's questions of Mr. McBride.
Yeah, can I ask you one question
Sure.
on that set of issues, which is where in this record or in the Rule 1000 Order 1000 compliance record would one find some very rough estimate of the quantification of system-wide benefits that would justify the 50-50 hybrid? I mean, it just seems like there's an intuitive appeal to that hybrid, but you know that all postage stamp is no good because the Seventh Circuit has said that, and all defects is no good because we said that in Old Dominion. And it just reads a little bit like a Goldilocks theory of rate making, which is 100% one way or the other, no good. So 50-50 is in the middle. Is it where would we find some justification for the 50-50 other than just happens to be in the middle?
I think I can point you to what the commission said in the December order. This is JA 390. This is a paragraph 44, and it provides an explanation for each of those pieces. I'll just point out that at least with respect to the postage stamp piece, and some of the questions to Mr. McBride indicated this, it does not appear that the petitioners have a problem with the postage stamp approach and the notion that there are broad region-wide benefits to these facilities. With respect to—
I agree. I agree with that. And I think the defects component of the 50-50, you've given some rough justification, which is flow. Flow can be a proxy for dollars. And that's without prejudice to the challenge in the separate case, but for purposes of satisfying Judge Posner and cost causation, good enough. I don't see anything like that. Put aside the question of whether these petitioners are the right parties to be raising the concerns that Judge Posner had about postage stamp, but where is the attempt to quantify the system-wide benefits that are, if you upgrade something in New Jersey, the power plants in Chicago are going to benefit from?
So I can't point you to anything in the record that attempts to quantify the regional benefits. What I will say is that both the commission and this court and the Seventh Circuit have repeatedly stated that, generally speaking, enhancements to a transmission system benefit the entire system. Now, obviously, the Seventh Circuit had an issue with the assumption that 100% of the costs of those can be shared on a postage stamp basis. And that's the problem where you have someone in the Midwest having to pay for really facilities in the East to remedy reliability violations in the East. But there does not seem to be a dispute anywhere that at least there's some benefit to users of the the transmission system writ large based on enhancements to that system. And I guess the question here is not so much, I mean, you point out the Goldilocks methodology, but at the same time, we're not here to find whether there's some more optimal alternative. The question is whether what the commission did is reasoned decision-making and whether it is overall just and reasonable within the meaning of commission policy and the second trailblazer approach. We haven't seen anything from the petitioners to question that. I think they repeatedly argued that the commission completely failed to quantify benefits, but the fact of the matter is the flow-based piece of the hybrid methodology does in fact attribute benefits to individual users based on their projected usage of the system. That's something the Seventh Circuit acknowledged. If I can just clarify one piece that came up a few times from your questioning, Judge Katsas, with Mr. McBride, there were a few questions about whether they were complaining about the component pieces of the hybrid methodology or just the 50-50 method itself. Mm-hmm. Answer that you got back seemed quite different than what we've seen in the opening brief. And so I just want to clarify this. There were some references to the de minimis issue, the de minimis threshold and the netting issue. That was raised for the first time on the reply brief. The opening brief, the only reference to the de minimis threshold is in page 12 of the facts section. And that's that, I think it's in a footnote, and that specifically notes that these issues are, the substantive validity of that method is a, quote, key issue in the 151183 appeal. And there's no mention at all of the netting point. So to the extent that the petitioners are now trying to bring in those issues, I would say those are forfeited. There was one more point that was raised in terms of the petitioners claim that they are not better off. The commission relied upon expert testimony that was unchallenged in the opening brief that found, for example, that with one exception, all of the contesting parties were allocated lower costs under the settlement than they were under the prior postage stamp methodology.
But that's a big exception, right?
Yes, the one exception is the Susquehanna-Roseland project. And with respect to that project, there was also expert testimony that found, and the commission agreed, that the costs that were allocated under the settlement for that project were substantially similar to what they would have been under the hybrid method.
But not under the postage stamp method. I actually think you all agree, like the petitioners are worse off under the hybrid method than they would have been under the postage stamp method, right?
Well, okay, but that might be.
Say, well, they actually are better except for one. Well, I mean, it's kind of like, you know, it was a good day at the theater for Lincoln, except for the assassination. I mean, it's a big exception. They're $15 million worse off, right?
So but so the question under commission policy that was whether they are no worse off under the terms of the settlement as compared to continuing in litigation. And so what the commission found based on that expert testimony with respect to that one exception is that because that project was placed into service fairly close to the 2016 cutoff date when the hybrid methodology under Order 1000 starts, most of those costs are going to be recovered under that method anyway. And so the settlement's allocation with that project is going to be substantially similar to what it would have been under the hybrid method.
Doesn't this question of whether they're better or worse off boil down to the underlying merits question of whether postage stamp would have been the prevailing method?
I mean, in some respects, I think the issue under Trailblazer is making a prediction about what would have happened if you continue the litigation out to its conclusion. Right. I think what the commission found was that
if the prediction is that postage stamp would have prevailed, these folks are clearly worse off. They're $30 million worse off under the settlement. So your position on this has to be that that was not a plausible outcome for all the same reasons that you now advocate 50-50 over a pure postage stamp or a pure defects.
I think that's right, Judge Katsas. And I think the commission said that because of the fact that the Seventh Circuit was quite emphatic on two separate occasions as to the problems underlying the 100% post-stamp approach. We haven't seen anything to indicate that continuing litigation would result in a 100% postage stamp approach at the end.
All right. Let's hear from Mr. Longstreth for the interveners then.
Thank you, Your Honors.
Thank you. And I'd like to just briefly address some of the points from the perspective of the respondent intervener parties, who include 9 transmission owners, 6 state regulatory commissions, and PJM itself. We believe the settlement's unquestionably in the public interest, and the Commission properly considered the positions of the 2 parties that are objecting to it here. I'll start by going back to Judge Katz's point about 50-50 and Goldilocks and all that. If you look at the PJM compliance, Order 1000 compliance order in 2013, which was the basis for this, because that was the basis for the settlement. The Commission went through very carefully why the 50-50 took into account both the regional benefits and the specific flow-based benefits, and no one objected to that, including these parties. If these parties, as you point out, are not really, the proper position to challenge that here, there's really nobody challenging it. And I think it really was something that, that the market to some extent has spoken. All of the interested parties got together and decided that really was something that was a rule that applied. So, part of the problem with the region-wide benefits, and I know Judge Posner went into this a little bit, but it is very hard to quantify those specifically. That's the whole point of a postage stamp system. But the idea, I think, that the problem the Seventh Circuit had was if you go entirely postage stamp, people who have nothing to do with the project are paying even more, for example, than people are taking flow directly from it. And the solution-based defects, as I think you pointed out, takes care of that. And again, that's not the situation we have at all here with these parties. These parties are taking energy from the Susquehanna-Roseland project. It was built to resolve problems in northern New Jersey. That's where these people are. They are benefits. As a matter of fact, the Commission pointed out they would have benefited even under the old violation-based system. There is testimony directly in the record, JA 241, that points out that the flow they're taking from this project is greater than the amount that they're being charged under the settlement for the project. So again, this notion that no one presented testimony as to benefits, there it is. It's in the gas declaration. There was also a McGlynn declaration. There was a Schnitzer declaration. As FERC counsel pointed out, all of those were ignored in the opening brief, where the petitioners were incorrectly arguing there was no evidence of benefits here. So I think that kind of puts that all out. On the de minimis, I think FERC is correct that that was something that came up at the in the reply brief. It was also something that came up, I think, in the agency proceeding, kind of at the end as they're trying to throw a bunch of stuff against the wall to see if they can do something to derail this settlement. The only thing I would point out on that is I think Mr. McBride mentioned, well, that allows somebody like Public Service, Electric and Gas, PSEG, to avoid responsibility. PSEG is paying, I think, at least 60% of the cost of this. This notion that somehow a de minimis rule is being applied in this case, whatever their problems with it might be in some other case, the notion that it's being applied in this case so that parties can avoid their responsibility is, I think, just fanciful. The Commission had that all in front of it. We presented testimony. They presented testimony. The Commission considered that under a paper record, as they do in very many cases, and that was pretty much it. They can support it under the as a proper settlement that's certainly well within the bounds of reasonableness. The only other thing I wanted to raise was the contractual issue that Linden has gotten into. The only thing I would point out, I think, Judge Katsas, you talked about the settlement offer, and you mentioned, well, maybe that doesn't have quite the quite the weight. The settlement offer is a filed agreement that's part of the settlement. So this isn't a situation where the settlement offer is some kind of parole evidence or legislative history that's trying to be used to override the language of the agreement. And the language of the agreement, I think even Mr. Konopka said something on the order of, well, if it had said the period in which it's collected as opposed to for which it's collected, that was really a problem. All we had to say was for which. And, the intent of the settlement would have been effectuated. I think you're getting awfully fine into these very intricate arguments. I'm not going to get into all of that, except to just point out that the general principle, and there's a case that you guys have, Arkansas Public Commission versus FERC. It's an unpublished decision, but it does go through the general principle that when you withdraw from an agreement, if you have accrued obligations, I think they say in that particular case, FERC concluded that a party's accrued contractual obligations continue beyond its withdrawal from a contract. What happened here was they had obligations under the contract because they had firm withdrawal rights. They decided a couple years into the period in which these charges were being collected for, the 10-year period. Well, we'll just get rid of our firm withdrawal rights and we'll avoid our obligations. And I think the quite natural response to that is, okay, maybe that's fine going forward, but you've accrued these obligations for 2 years during the period. That's what we had set up this whole settlement designed to collect. And, you're responsible for those 2 years, even if you got out of it for the 8 years after.
All right, Mr. Longstreth.
Very consistent.
This guy is calling time on you. Thank you.
I'm sorry. Thank you. And I appreciate the court's indulgence.
All right, Mr. McBride, why don't
Mr. McBride, you're muted.
Can you hear me now?
Yes.
Thank you. So first on the commission's point that we didn't put in the opening brief anything about the problems with the lack of evidence about benefits and how they would be applied to these projects. We did indeed do so at pages 35 to 36 of our opening brief. And we showed that the benefits did not flow equally to all the, with respect to all the projects, and that the merchants derive different benefits. And we had evidence disputing the methodology in general, as well as the specific application to the vintage projects. The point is, and I think FERC conceded, that there were no quantitative findings that it made on cost benefit. And the roughly commensurate test requires that there be such. There has to be some showing that costs and benefits are even roughly commensurate, and there is no finding here from the commission to that effect. So that the commission simply can't satisfy the mandate. I want to point out that at page 12, note 3 of our opening brief, as well as page 37, note 11, and in the recent SCNG versus FERC decision of this circuit, there are numerous examples of how the general methodology does not produce roughly commensurate benefits in accordance with the costs that are allocated. So, it seems clear to me that what happened here was FERC didn't want to put on give us an opportunity to show on an as-applied basis or otherwise that the evidence was such that there was a roughly commensurate balance between costs and benefits.
All
And
right.
so I'm sorry.
go ahead, finish your thought.
I finished, Judge Henderson. Thank you.
All right, then, Mr. Konopka, you asked for 1 minute in reply.
I did, Your Honor. Thank you. I think I'd like to make just a couple of points. Mr. Longstreth, I think at the very end of his argument, suggested that there's some free-floating intent of the settlement that's somehow not embodied in the text, and that the court should construe the text in accordance with that intent. But of course, the text is the best evidence of the intent of the parties. And here, he didn't say anything about in which meaning something other than in which. The second point I'd like to make is there seems to be some idea that there was an accrual of a liability here. Our whole point is that the settlement provision talks about the rates and charges due under the settlement. And of course, the exception that we're relying on means that our rates and charges due under the settlement are zero for the adjustment.
Mr. Konopka,
Yes.
let me, I know our time is short and we've been quite in the weeds of the JA, but let me ask you one question about JA 102, if you could go there, please.
Sure.
I'm going to ask, this is the paragraph immediately following the key paragraph, whose meaning we're trying to figure out.
Is this subsection 3 or section 5?
It's subsection 3. It's talking about Con Ed New York. And what's been done here is it seems like maybe the parties were anticipating that Con Ed might jump ship, and they wanted to kind of account for that possibility. And so they use the phrase "are collected," and I'll just read it. Con Ed New York terminates its agreements with PJM during the period in which transmission and charge adjustments are collected. Then blah, 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 this stuff happens. So they're using the exact same phrase as the phrase before. Now, here's my question to you. If you're right that that are collected means literally the money is going from one party to PJM, that would not explain what happens in the event that Con Ed New York jumped ship before the settlement was approved. So they've accounted for what will happen if Con Ed jumps, under your theory, they've accounted for what would happen if Con Ed New York jumps ships after the settlement is approved. But they have not said anything about what would happen if Con Ed New York jumps ship before the settlement is approved, which seems to me an awfully large thing to not account for when you've written this whole paragraph all about what to do if Con Ed decides it doesn't want to be part of the service agreements anymore. So don't you think it's weird? Don't you think that if you're right about what "are collected" means, then this settlement agreement made a large and odd omission and failed to account for the possibility that Con Ed New York would terminate its agreements in this period between January 1st, 2016 and the period when the settlement agreement is approved?
It's a good point and a good question, Judge Walker. I think ultimately, though, what the parties agreed to in subsection 3 is that Con Ed couldn't get out. And in fact, that subsection or that paragraph is really inoperative, because if you look at the other provisions, it says that adjustments can be changed only under paragraphs 1 and 2. So I think all this was really getting at was making clear that Con Ed can't get out, period.
But does it allow Con Ed, let me ask, does it allow Con Ed to get out, let's say on June 20th, 2016, that's 5 days after the settlement agreement, but it's well in advance of when the settlement agreement would have been able to be approved and when literal collection would have been able to begin?
I think under that circumstance, obviously the settlement doesn't speak to that circumstance.
That's my point. So that's my question. Like, the fact that the settlement under your theory doesn't speak to that circumstance, to me suggests that maybe your theory is not correct.
Well, again, I think it's sort of hard because this provision is not actually operative. It doesn't really do anything, but I think probably what would likely happen is that they wouldn't be able to get out in that circumstance. But obviously the settlement doesn't speak to that.
Why would Con Ed
or they would be subject to the.
If Con Ed wanted to get out, if Con Ed New York wanted to get out on June 20th, 2016, why would they not have been able to get out?
Well, so Con Ed was actually due credits under the settlement, so they wouldn't have wanted to get out of these.
Okay, so that's helpful. That's like a theory for why maybe this is done the way it's done.
Exactly. Thank you.
Thank you.
All right. Thank you, gentlemen. And the case is submitted.
Case number 19-5005 et al. Cook Inlet Tribal Council, Inc. versus Christopher Mandregan, Director, Alaska Area Office, U.S. Indian Health Service et al. Appellants. Mr. Coppell for the appellants, Ms. Patterson for the appellate.
May it please the court, I'm John Capel from the Justice Department representing the appellants, the Indian Health Service in this case involving, this appeal involving the Indian Self-Determination and Education Assistance Act, known as ISTA. Under ISTA, the plaintiffs are tribal organizations who seek to operate programs that were previously operated by the government under are entitled to receive be treated on equal footing with the government. They're, as say, are supposed to receive the resources that the government would have used to implement the program. And the Congress has established this parity principle in 25 USC 5325A, and that section contains two funding categories. First is A1, which is the basic substantive program cost known as the secretarial amount, and then the second category is contract support costs, which are found in subsections A2 and A3, and the contract support costs provide additional administrative funding for additional administrative costs that are not covered by the secretarial amount. The district court and the plaintiffs, however, seek to blur the distinction between the secretarial amount and contract support costs, and to turn the contract support cost provision into an open-ended supplement to the secretarial amount. Congress wrote no such blank check, however, as is clear from the plain language of 25 USC 5325A and from the structure, purpose, and history of the ISTA. Turning to the history of these provisions, Congress in 1975, when it enacted ISTA, it provided only for the secretarial amount. That is the core amount that provided funding, substantive funding for these programs. However, it became apparent to Congress thereafter that that was not sufficient because tribes were having to expend additional additional resources for administrative costs, and therefore were eating into the substantive program amount. So therefore, in 1988, Congress enacted the core contract support cost provision in 5325A2, and that established that tribes can get administrative costs for certain items, for things that are not normally carried out by the secretary through the secretarial amount, and also items where the funding is provided from resources other than the contract. Now, the Congress further refined the statute in 1994 when it adopted a subordinate contract support cost provision in A3. That simply refined and clarified the meaning of contract support costs, which is set forth broadly in A2, and it provided for direct and indirect contract support costs. However, again, this was done because Congress was concerned that tribes were being forced to use funds from the secretarial amount for administrative costs that the government would not have had to incur. So,
Mr. Capel, may
yes,
I
sir.
ask you about how your agency reads 3A little, what I call little I?
3A,
Uh-oh.
which provision, Your Honor?
Judge Henderson, you may have cut out there after 3A.
Additional administrative or other expense related to the overhead. Can you hear me now?
Yeah,
Yes,
you
I did.
cut out
But
for-
you're on, I just want to be clear, you're referring to little a, to A2, little a, little 2?
No, to 3 big A and then little 2.
Little 2. Well, that's,
right.
sorry,
And
I misspoke.
yes,
Yes, Your Honor. First of all, I would
well, let me just ask my
emphasize-
question. Let me
I'm
just
sorry.
let me ask my question. Okay,
Sure.
that says any additional administrative or other expense related to the overhead. Now, do you read administrative to have to be related to overhead, or do you read administrative expense or other expense related to the overhead? And then what do you consider overhead? What does the agency consider overhead?
Well, first, before I answer that question, Your Honor, I would like to stress that provision, 3A little 2, is not involved in this case. This case only concerns direct contract support costs under A little 1. So that has
Well, the reason
yeah.
the reason it's interesting to me is why overhead, which I can't find defined anywhere, would not include rental costs, so forth, of this facilities cost.
Well, Your Honor, we don't read read overhead that broadly. We believe that overhead it concerns items that are where the government is providing sort of across the board funding. It's not sort of separating out items that are
Can I find that anywhere where overhead is set out as what it includes?
Well, Your Honor, I don't think that we have that the statute or the Indian Health Manual really defines overhead. But when you look at the way the statutory provisions interact, it is clear that overhead is a more limited category. And in section A2A, that is the basic contract support costs provision, and that really does not. That provides for things like workman's compensation payment, premiums, and insurance costs that the government does not have to pay, and then A2B applies to things like attorney's fees, which the government provides for from resources outside of the contract. A1 in 3A1 in the government's view, which is the direct contract support provision, direct contract cost provision, deals with things like rents and facilities costs such as are involved here. That is not overhead within the meaning of 3A little 2. It is.
How about utilities and phone and water?
again, those would be considered direct costs under 3A1 rather than overhead under 3A2.
All right. All right. Thank you.
Does it matter? I thought your main theory, I'm a little confused why you seem to want to frame the answer to Judge Henderson's question as one about 3A1 versus 3A2. I thought your primary theory, tell me if this is wrong, but your primary theory is it doesn't matter whether or not they satisfy 3 because they also have to satisfy 2 independently.
That's correct, Your Honor. 2 is the principal contract support cost provision. It's essentially the gatekeeper. They have to be within 2 before they even get to 3. 3 really is a refinement and clarification of 2.
So can I ask you one question about 2?
Yes.
Which is, to me, this case seems to come down to the question whether the kinds of costs that are at issue here, the rent and the salaries and the utilities, are items normally not carried on by the secretary in operation of the program if the federal government ran the program.
That is the government's view, Your Honor. Yes.
Make the intuitively appealing point that this seems pretty self-evident that if the government runs an alcohol treatment facility, they're going to have rent costs and salaries, and they have to pay for telephones and such. What is, how should we think of that question? Is it enough for you to win just by saying, give me a break, this is self-evident, or is that something you have to prove with, is it something you somehow have to prove with record evidence or a Brandeis brief or I don't know what?
Well, Your Honor,
how do we figure that out?
Your Honor, in our view, it is clear on the face of the statute. This is the only way. This is the way the statute works and the way it makes sense. This is the way to harmonize the various provisions, the secretarial amount provision and the contract support cost provisions. And it's consistent with the history of the ISTA and it's also basically, this is, in our view, this is the clear meaning of the statute.
Sorry, how does the statute on its face make clear what activities the government would normally carry on if it were running this facility?
Well, Your Honor, certainly things like rental costs, like salaries. These are things that obviously that on their face, the government would have to, would normally be carrying on to operate its program. There's no question here. As a matter, here there actually is record evidence that there was that from the original contract in 1992, FY 1992, that facilities costs were included, and the plaintiffs acknowledged that the $11,838.50 figure. So there's no dispute. There certainly can't be any dispute in this case that this was part of the secretarial amount.
Included in the secretarial amount.
Yes, Your Honor.
Which is
so
okay, which tends to support what the seemingly obvious but maybe not proven proposition that those are costs that, of course, the government would incur if it were running the program. It is awfully dated, but I take your point.
Yes, And one final thought on that. The Indian Health Manual is also consistent with that because it says with respect to things like rents that in extremely, it's only in extremely rare circumstances that that rents could be treated as contract support costs. That is because they are generally within the purview of the secretarial amount. So
All right.
thank you. I will now reserve.
We'll give you a minute and reply. Ms.
Thank you,
Patterson.
Your Honor.
May it please the court. This case centers on two statutory provisions, one general and the other quite specific. The general one announces that the secretary must add contract support costs to the contract, and the later enacted very specific one, section 85325A3, defines with precision exactly what those added contract support costs are. The general
Ms.
provision.
Patterson, would you be able to pick up perhaps where Judge Katsas' questioning left off, and I'll phrase it this way. When Indian Health Services directly operates a hospital, it almost always pays for facilities costs like rent, right?
No.
Okay, tell me why I'm wrong.
So the Indian Health Service, first of all, may incur some facilities costs, but not necessarily of the same kind and like that a tribe might incur. Rent is a good example. The government may rent a building. The government might just own it outright. Things like a mortgage. The government does not incur mortgage costs. The government either has funds to buy a building or it doesn't, or funds to build a building or it doesn't. Property insurance. The government self-insures. They don't buy commercial property insurance out on the market. And this was some of what the district court struggled with when they said that when he said there is no definition of what the secretary quote unquote normally incurs. And the other thing is that the statutory text in A2 directs you to look at the secretary and his direct operation of the program. Well, in most cases, as Mr. Capel pointed out, a tribe is taking over a program that the federal government is running, and they know what the federal government incurs. There's an actual budget, the actual expenditures. This is a unique case because the government never ran this program. And so the parties agreed to what a budget of what that would incur. They agreed what cost the secretary normally would carry on. Here it was a portion of rent, and it was a portion of a facilities coordinator salary. And here the government agreed that the council has over $302,000 of other reasonable, allowable costs related to the subject of the IHS contract that have not been reimbursed in the secretarial amount. So that's why we're here today.
Let me ask a different hypothetical, maybe, and that answer was helpful. I appreciate it. Let's take a less general question. Imagine that IHS wants to open up a hospital in Anchorage on land that the government doesn't already own. And that's somewhat analogous here because here the Cook Inlet presumably opened the rehab treatment on land that it did not already own. Am I right about that? They didn't already own this land when they opened the treatment center, right?
Correct.
Okay, so government IHS decides it wants to open a hospital in Anchorage on land that it doesn't already own, and it's going to operate that hospital directly. It would have to either buy the land, which would be an expense, or it would either have to rent the land, which would be an expense. Is that correct?
Correct.
So in that case, I don't understand how this wouldn't be almost a textbook example of a secretarial amount. This is a cost that IHS would almost always have to pay out of its pocket if it were going to operate directly the type of facility that Cook Inlet is operating.
So I'd like to make a few points in response. First, we agree that if facilities costs had been paid in the secretarial amount, the federal government would get an offset, that would get a credit for every dollar, for every facilities cost that they had and they transferred to Cook Inlet. The issue is here, this federal government was not operating that facility, right? And so all they provided was $12,000. And we give them, or I mean, it was $11,838, but we give them credit for every dollar that they've shown that were transferred. And the whole contract support cost provisions were added, and as Mr. Capel explained, because the agency was underfunding indirect costs. They were underfunding.
Ms. Patterson, let me ask about that. Let's say I take as a given what you just said, that IHS is underfunding a program that they agreed to fund. And it probably would not be the first time IHS underfunded a program it agreed to fund. I would think that your remedy in that situation is to say your secretarial amount is too small. So give us the extra $300,000 as an addition to our secretarial amount. Why didn't you ask for that? Why didn't you go to court and demand that?
Well, there's a few reasons, but the first is we're not talking about expanding the program. That's the government's argument. We're talking about the subject of the IHS contract, and we're looking at the funds that are needed to run that IHS program under contract, so that the program that the council runs is on parity, like Mr. Capel said, with the same program.
No, I get that. That was I may have misspoken, but that was supposed to be a kind of a given, an assumption in my question. Let's say IHS authorizes this program as it currently exists. Every bed, every square foot, everything. They've authorized that program, and yet they've underfunded it by $300,000. That seems to me to suggest that what Cook Inlet needs to do is go to court and say our secretarial amount is $300,000 less than the statute requires IHS to pay. And so maybe there is a strategic reason that Cook Inlet didn't do that, or maybe you're going to tell me that I'm misreading the statute and what secretarial amount means. But I am curious, why wouldn't Cook Inlet have just done that?
I mean, maybe that would have been an option, but you also have a statute that says these overhead, administrative, support costs, the costs that are necessary to run the program, are recoverable as contract support costs. And so
if they're not normally paid by IHS, were IHS to operate this program directly.
But what does that mean? You have to look at the direct operation of the program. And here the direct operation included $12,000. It included a part of rent. And then when they added additional funds in around 2004, there was no funding of facilities, because you have these statutory provisions that allow a contractor, if they have, to not have to take from those program dollars, not have to take for the money that pays for those counselors and those treatment beds and the people with the white jackets, but there is a funding mechanism available for the necessary support costs to operate the program. And there's a whole manual, and facility support costs are one of the main 3 categories of contract support costs that can be recovered.
Suppose it were crystal clear that we were talking about a category of expense that the government would have to incur if it were to run the program, whether it's rent or salaries or whatever. Just assume that's clear. And the secretary, if he ran the program, let's say, would spend $1 million. And let's say that the contractor reasonably spends, I don't know, $1.2 million on that category. And it's reasonable, but it's more than the secretary would have spent. So you get, your theory is you get to recover that extra $200,000 because it's a reasonable expense. no matter how much it is the kind of thing that the secretary spends, and he just wouldn't have spent as much.
If it's a support cost, yes. And let me give you a real life example. I'm going to take us out of facilities context for a second and talk about health insurance. The government provides health insurance for its employees. Everyone agrees they have to do that. But the government generally has the federal employees health benefits program, and it's good insurance and it's pretty cheap. Tribes, when they provide health insurance for their employees, they have to go out on the commercial market and purchase that insurance. And it's often at quite a bit higher expense. Direct contract support costs pay that difference between what the tribe pays on the commercial market and what the federal government pays for its health insurance. It's the same type of item that the government is providing, but the contract support costs are there so that extra premium, if you want to call it, that the tribe has to pay does not have to come out of the program costs. And you actually see this in the IHS manual in Exhibit 6-3-G. They actually have a chart with theoretical health insurance amounts, right? The government pays $200 and it costs the tribe $300, and that $100 come out. And it explains, after determining the total cost of the activities to be supported with CSC, IHS will deduct any funds that may have been provided to the awardee in the secretarial amount for this activity to avoid duplication of costs. So that's what we're talking about here.
Okay.
All right, if there are no more questions, Mr. Capel, why don't you take a minute if there are any questions for you? Oh, gosh.
You're on
You
mute.
can't. Okay.
There you go.
Thank you, Your Honor. I would respectfully disagree with the last thing that counsel said, because we're not talking about insurance costs here. We're talking about rental costs and salary costs, which certainly are part of the secretarial amount, and they are not part of 2A.
What's your answer to the conceptual point that sometimes it's the same category of cost, but it's obvious, it's much cheaper to the government than to any other provider?
Your Honor, if it's the same category of cost, then it's within the secretarial amount that unfortunately they are not able to get additional contract support costs for that. That's not the purpose of contract support costs. It is a categorical non-duplication principle.
So for workers' comp, federal government just they self-insure,
right?
And so that's a different category, and so that's recoverable.
That's right, Your Honor.
But for health insurance, in the providers, they sort of buy it, but sort of not. I mean, FEBA is, Ms. Patterson is right. It's freakishly cheap and good to those of us who are lucky enough to have it. But yes, because that is hugely subsidized and but costs IHS a little bit, then the provider who has to pay 3 times as much on the open market to get that insurance is just out of luck.
Well, to the extent that insurance that any costs are within the secretarial amount, that is true. They can't just get the difference through contract support costs.
Mr. Koppel, why not just say, if it's correct, that the example Ms. Patterson was giving is textbook contract support costs, that the secretarial amount covers what the secretary would have paid, but there are other necessary expenses that the secretary wouldn't incur, and that's where contract support costs kick in. But with rent, we're talking about bread and butter secretarial amount, because assuming the government doesn't own the land already, just as Cook Inlet doesn't own this land already, The government wants to rent 1,000 square foot. It's got to pay the market price for a 1,000 square foot. If Cook Inlet wants to rent 1,000 square foot, they should get that amount, whatever the amount is for that rent, from IHS. If they're not getting that much, then they should go to court and they should demand the difference as part of the secretarial amount. Now, if Cook Inlet decides, well, it's reasonable to rent 1,020 square feet, and so there's going to be an extra cost there that the government wouldn't incur because the government would only pay, were it running the program, 1,000 square foot facility, then that is extra money that's going to have to come out of Cook Inlet's treasury, and it's not going to be reimbursed, right?
Your Honor, that's exactly right. That is precisely the government's position here. And just to close very quickly, I would point out that there was a lump sum increase. The total in 1992, when they were only getting the 11,838 for rental and salaries, Congress added 1.5 million to the secretarial amount for Cook Inlet in 2003. So it's now approximately 2 million. And this is lump sum. So even there's no reason to think that they're limited to the 11,838 that they originally got for rent and salaries. That there it is the tribe gets to it allots the lump sum as it sees fit, but it is obviously limited by the parameters of the secretarial amount. So if there are no further questions, I would urge the court to reverse the judgment of the district court.
All right, thank you. And Madam Clerk, if you'd give us an adjournment.
This honorable court is now adjourned until Friday, May 14th at 9:30 a.m.